Hello everybody, welcome. Today we're going to look at another FMLA case. So this case was filed in the District Court of Colorado, and the plaintiff, the person that is suing, is a Colorado resident, and the defendant is a Delaware corporation. So here are the factual allegations. The plaintiff began working for the defendant, the company, in 2014 as a chief compliance officer, and his performance was always exceptional. In 2015 he was even promoted, and then his wife had their first child and he took paternity leave, and then following his return after the paternity leave, he was told that they were not happy with the amount of leave that he had taken, and then he was expecting a second child. And then, concerned about the response he had received previously for taking the paternity leave, he inquired as to FMLA, which stands for Family Medical Leave Act, to the human resource manager. She responded by telling him that he was not eligible for FMLA. Despite the defendant's initial rejection for the request for FMLA leave, he researched the issue on his own, and then he later learned that he was actually eligible for FMLA, and he applied for FMLA through their parent company. The company's parent company was ADP, and ADP approved his initial leave request. While on leave, I guess the CEO was replaced, and when he returned to work, they asked him to change his upcoming FMLA leave to travel to London, and then he submitted paperwork through the ADP for second portion of his FMLA leave. And then what happened is that the defendant approved the second portion to begin the next month, and they acknowledged that he was eligible for FMLA leave, and then he must be reinstated to the same or equivalent job. And then on January 29th, 4 days later, the chief people's officer sent him an email informing that the employment was going to be terminated following the expiration of his FMLA leave in March. Something to know is that there is no FMLA claim if you still have a job, which is sad because there's no back pay calculation or front pay calculations. So if you still have a job and there are issues with FMLA, unfortunately there is no venue because there's no damage that can be calculated. Okay, so he was terminated, so there is a claim, and on March 15th, after he made a complaint, they only paid him 80% of his target bonus. All right, so here are the causes of action. He is a qualified employee. There are some criteria to meet FMLA leave, and he is qualified. And then they retaliated against him for requesting FMLA leave because they subjected him to adverse employment actions, including termination of his employment. Like I said, if there's no termination, there is literally you're not going to be able to win anything since there's no back pay or front pay calculations. And the defendant discriminated against him for taking medical leave by terminating his employment. So again, this is what his attorney had filed asking for. All right, so this is another example of FMLA case that is happening in the employment world. Thank you very much.